The jury asked to hear parts of the jury instructions specifically that dealt with the idea of facts and inferences that can be drawn from facts. And specifically, they want to know about something called the rain metaphor. With us now, CNN legal analyst Joey Jackson, Jeremy Salan, Jim Schultz, also with us from remote. Joey, very quickly, the rain metaphor and what that might mean here.
Okay, very important, right? A fact is a fact. I see it, I know it. It's substantively a fact. There are other things that are facts, but I may not see. Why is that critical here? Defense arguing that Cohen provides the only direct link. If that's the case, prosecutors say, not only do we have things that corroborate Cohen, but we have things we can draw inferences from what he said, right? Circumstantial evidence, John. What is circumstantial evidence? We all walk outside right now. We don't see a droplet of rain coming from the sky, but the cars seem to be wet. There are puddles that are in the street. There are other people who are wearing raincoats. What can we logically infer? That it was raining outside. So, did you see it, John? Did you see it, Kate? Did you see it, Jeremy? None of us saw it, but we could reasonably infer based upon the surrounding circumstances that it happened. That's the prosecution's main argument here. If the jury buys the circumstantial rain metaphor, it spells trouble for the defense.
And we'll just throw in a little common sense. That's the other word we need in there as well. Common sense.
Yes. Also, the rain metaphor sounds even more ominous the way Joey was describing it. But Jeremy, talk about if they want more information and we read the tea leaves on it, this has the defense team sweating.
Absolutely, absolutely. Even if we don't see the sweat, but we see it over here on the lapel,
well played.
We have that common sense. Yeah, so absolutely, seems favorable. We don't know, we're not there, but it seems very favorable. Even the reading of the first jury instruction, of the first count of the indictment, that's not because they're really stuck on whether that particular item was a falsification of business records. That is all for the same 34 counts. They want to know what the elements are. This is moving and progressing in the right way for the prosecution.
And Jim Schultz, if you are with us, in a way, the prosecution's case is a rain metaphor case. It is the sidewalk is wet case, type of case, an inference from facts. Now, we don't know why the jury wants to hear that. We don't know if there is 12 jurors who want to acquit, but one jury is saying, we need to hear the rain metaphor, so I want to convince the other 12 of you. That could be it. But this is a sidewalk is wet type of case, isn't it?
Well, yes, it is, and I think this is just indicative of the discussions that they're having, right? And I think you hit it right on the nail right on the head. I think they're probably debating right now. Look, there's not if they don't believe Michael Cohen, right? Then how do they get there? And they have to get there through circumstantial evidence. And I think that's probably the internal debate going on right now. There are probably some jurors that are saying, I don't think it gets there. There are probably some others saying, yes, it does. And as they continue to deliberate, they're going to want to hear so that no matter what camp you're in that jury room, they're going to want to hear, what the judge has to say, what the instructions are as it relates to that circumstantial evidence so that they can try to come to some agreement.
One of the other things that came up is that the judge, one of the notes was that they wanted to be reread the first count. They wanted how this all relates to the first count. And Jeremy, just reinforce this point, because you think it's not about count one, because count two, 3, and 4 are the same.
Correct. I mean, you theoretically can find something was falsified and something wasn't, but it's the same elements. It doesn't matter. You can take out the factual piece, meaning what was allegedly falsified, whether it was an invoice or a check, but the elements are what's critical. And if they're asking for the circumstantial evidence and they want to know all this read back in terms of the jury instructions, it tells me to the point that was just made. It doesn't mean that everyone is on one side. They could be trying to convince a couple or a lot, but this is progressing, if I'm the prosecution, in the way I want it to progress.
And Joey, after all this is done, and this is going to take a while. All the readbacks will take, maybe an hour here. After that, what are you watching for? Do you think this may be it from the jury, or do you think there'll be more questions, and about what?
So, John, hard to tell if it's it. We know what they're struggling with, right? Based upon what they're asking for. Was there a conspiracy or a cover-up? That's the prosecution's theory. So they're going back. What did Pecker say? What did Pecker say to Trump? What did Pecker, when they met with Cohen and Trump and Hope Hicks coming in and out of that meeting, what happened there? We know what their focus is, and they want to be apprised as to specifically what the law is, but they may have additional questions as they go back. We know, obviously, what their thought process is as of now.
The jury in Donald Trump's criminal hush money trial is back to work. The 7 men and 5 women will ultimately decide whether a former president is convicted of felony crimes for the first time in the history of the United States of America. And Mr. Trump is in court awaiting their decision. We just learned that the jury has submitted yet another note. This is the third. One about yesterday's request for the judge's instruction to be reread, and another requesting for headphones to use with the evidence laptop.
Yeah, clearly a tech-savvy jury because they asked specifically for a certain kind of headphones here. But Jake, of course, before those jurors left yesterday to go home, they asked to rehear 4 key pieces of testimony throughout this trial, including from Michael Cohen and the former National Enquirer tabloid king, David Pecker, and his account of the 2015 Trump Tower meeting. Also, Pecker's 2016 phone call with Donald Trump about the former Playboy playmate, Kara McDougal, and David Pecker's testimony about not finalizing a deal, a payment from Trump to reimburse AMI for McDougal's rights to her story about her alleged affair with Donald Trump. Just moments ago, Trump repeated some all too familiar false claims about a rigged trial as he walked into the court as we are waiting for the verdict here, but still getting into the notes as of this moment. Paula Reed and Kristen Holmes are here with me, and right now what the judge is doing is he's rereading the parts of the instructions that the jury was curious about. And there's one interesting part which was about David Pecker's non-prosecution agreement. Basically that he could not be prosecuted. He was boious basically on the stand, and what he's reading is, you'll recall that testimony you heard about when David Pecker was an executive at AMI, that they went into a non-prosecution agreement with federal prosecutors. And basically he was saying this is to help you as a jury assess his credibility. You're not supposed to deduce whether or not anyone else, the defendant here, committed a crime based on the fact that David Pecker entered into that non-prosecution agreement via AMI, but it's just to help you assess what he's saying to you on the witness stand. But it's notable that the jury wanted to hear that again.
Yeah, and to the jury's credit, I think we were all a little surprised that they wanted to rehear instructions they had just heard a few hours prior. But in seeing these sort of read back, we have the text. I get why they probably wanted to rehear this. Some of this stuff is really complicated. They wanted to hear things about the hearsay exception, and here they're getting into the burden of proof. And of course, if the government has proven this case beyond a reasonable doubt, you have to find the defendant guilty. But things like this, again, how you use David Pecker's previous arrangements, previous agreements with the government, that is significant, especially when they're clearly looking and evaluating at some of the things that David Pecker said. So this makes sense. And look, I definitely give them the benefit of the doubt about why they needed to rehear this and reiterate. It is crazy that they don't just give the jury a copy of instructions.
Yeah, they have to ask the judge to reread it. And right now he's reading the part about reasonable doubt. And this is this is a critical piece of this, Kristen, because obviously, and as the instructions laid it out, it would say that it's not beyond all possible doubt, but it's not, he's probably guilty. It has to be beyond a reasonable doubt. And he also is reiterating an important part that I know the defense obviously cares about, which is that the burden of proof here is not on Trump's legal team. It's on the prosecution for making their case here.
Well, exactly. And the defense really cares about that particularly because they want to be pointing to the fact that there were witnesses who allegedly could have corroborated Michael Cohen's story that the prosecution didn't bring, like Keith Schiller, like Alan Weisselberg, who's currently in Rikers. We believe that they weren't brought up likely because the prosecution didn't think that they would be friendly witnesses. These are people who are still Trump loyalists. Now, the judge is saying, whatever your verdict may be, it must not rest upon baseless speculation. Now, this is really interesting because we're talking about 2 different things here, and this is what the jury wanted to hear about. One, baseless speculation, say it cannot rest on this, but they also wanted to hear about that rain analogy, talking about inference and what you can infer and using facts for inference. So they're clearly kind of getting the difference here and re-listening to the difference between speculation and inference as he's going back through these.